Good morning, everyone. Delvin here. Um, yes, so I was just going to say I have the second judge joining now. Hello, Lee.
Morning,
Good
Delvin.
morning. Yes, so you're two
Can
judges
you hear me all
now.
right?
So if the team is ready, please go ahead and start. Good luck.
Then I shall begin. Um, May it please
Yes,
Your
please
Honor,
do.
I am Fatima Zahra Isaac. Sorry. May it please Your Honor, I am Fatima Zahra Isaac, and I appear in this matter on behalf of the respondent, Ms. Razwani, together with my learned friend Roshni Mehreen Sayed, and the appellant is represented by my learned friends. Before we begin, we find that the court must be notified that our oral submissions will contain two cases that have not been addressed in the submitted court bundle of the respondent. We ask that Your Honor excuses the same. The facts of our case, for your convenience, have already. Wait, I'm so sorry. I think there's a mistake. I'm so sorry.
The appellants are supposed to go first. We're the
Yes,
respondents.
I'm so sorry. That was a mistake. I apologize. I was a bit nervous and I started instead. The other team is still not here yet.
Lee, are you here?
Yes, I am now. I'm so sorry. It seems the place I'm at have a problem with their internet, but I believe it's fixed now. If you can see and hear me all right.
Can hear you and see you all right. I'm wondering.
For you.
Okay, the participants are here. Are the participants here? Okay. Is the University of Bolton here?
Yes.
Could you turn on your cameras, please? Fabulous. If Lee is with us, I think Lee is trying to sort out his problem with the internet. We can resume once he joins us. Could I perhaps ask each one of you to rename themselves as appellant and respondent?
Yes.
Appellant followed by your name.
University of Bolton, we are representing appellants on this case. And I'm Mohammed Shoaib, and my co-counsel is Mohammed Umar.
Yes, very well received. If you could rename on Zoom your team names, in a sense, you could make it appellant A.
Oh, on
and
chat. Okay.
Lee, I think it's just you. Lee, I think we can see you clearly, but there seems to be a bit of a background noise. Can you hear us?
I can hear it, so you don't get. I can hear you. I don't know if you can hear me.
I can hear you, Lee. As long as you're able to hear me, we should be fine. And you could chat in the chat box. As long as there is an affirmative on that, we should be fine. So why don't I take this from here, Lee, with your kind permission? Can the appellants tell us in terms of the order of proceedings? Appellant would go first, and then followed by the respondent, and then appellant, and then again the appellant junior counsel goes first. Is that the order? And then the junior counsel on the other side. In terms of time allocation, I would want it to be, or we would want it to be, considering the delay that we have had, to be quite tight. So if the appellant senior counsel could immediately start, as long as we have an affirmative from Lee that he can hear us, and that's a yes. So appellant senior counsel, please go ahead. I may have my video turned off for a moment, but I can hear you, see you quite clearly.
Okay, sir.
Mohammed Shoaib, it's yours.
Yeah. Do I start, sir?
Yes, please.
Okay. Your Lord, my name is Mohammed Shoaib. I'm the senior appellant on this case on behalf of Mr. Leith Payne. On the case of Mr. Leith Payne versus Ms. Rajdhani. Shall I proceed with the statement of facts, Your Lord?
Very briefly.
Okay. So Clevity is a digital platform on which users or traders can use algorithmic trading for concluding trades. So users can pre-program their algorithms on this platform to conclude trades without physical human interaction. Mr. Leith Payne and Ms. Rajdhani are such users on this platform. And this platform requires a minimum balance to be maintained by the users of $50,000. So if the users do not maintain a minimum balance of $50,000, they will be excluded from trading automatically. on 10th June 2022, the platform of Clevity underwent a routine upgrade, due to which it caused an error, and the error lasted for 30 minutes. And due to the error, the minimum balance requirement of $50,000 went up to $200,000. And during this 30 minutes of time, the only two users who maintained a minimum balance of $200,000 was Mr. Leith Payne and Ms. Raz Rani. Mr. Leith Payne and Ms. Raz Rani respectively have their algorithms pre-programmed named as beta and alpha. Beta is programmed to sell a certain kind of cryptocurrency, in this case, which is YAPL, at an average rate. And if there are no other sellers at a certain point, it will automatically highly inflate the price of YAPL and sell it to the buyer. And alpha, which is Mrs. Raz Rani's program, is programmed in such a way to buy a certain cryptocurrency, in this case YAPL, at the best average rate, at the best rate possible. So on this 30 minutes, on the 30-minute period of the glitch, both the programs alpha and beta concluded a trade where beta sold YAPL, a cryptocurrency, for 250 times higher than the average price. Ms. Raz Rani, whose program is beta, then filed issues in the court of first instance, claiming this case and the amount back. And the case was moved forward to DIFC courts. Your Lord, do I move with my issue now?
Sorry, yes, please do move on to the issues. I suspect that we've both turned our cameras off to try and preserve the bandwidth, but no, please do move on to your issues. You can hear me.
Okay, thank you. So I will be addressing the issue of contract law. The issue states that if the first instance court conclude that the purpose of a claim to avoid the disputed trade was sufficient for the purpose of Article 37, subclause 1, subclause A, and if Ms. Razi showed that a reasonable trader with the knowledge of circumstances surrounding the transaction would have concluded that the disputed trade was a result of an error. So, Your Lord, can I move forward with my arguments on this issue now? It's very well established in the statement of facts that all programmers have pre-programmed their algorithms to conclude trades without human physical interaction. And when Ms. Raz Rani had programmed alpha, she did it in such a way that would automatically purchase YAPL at the best rate possible. A question we repeatedly asked ourselves was, if this glitch was not to occur on 10th June 2022 for the 30 minutes, and the same trade would have been concluded without the routine upgrade, without the glitch, would she issue the same charges against Mr. Leith Payne under the court of first instance? The answer is in the question itself, that if the glitch did not occur and the same trade had happened, it's clearly a fair trade. And so it is a fair trade even when the glitch occurred. So in our arguments, we say that in our favor, we say that this glitch is being taken advantage by Ms. Raz Rani in favor of her on this case. Shall I move forward, Your Lord? Ms. Raz Rani implied that a reasonable trader would take appropriate precautions to avoid such disputed trades. In that case, my first point is, why did not Ms. Raz Rani use similar precautionary measures to avoid such trades on her behalf, as this disputed trade was a loss for her and it was a fair trade according to us? If Mr. Leith Payne was unreasonably trading under Clevity, he would have been excluded from trading after programming alpha in the first place if his program was violating the terms and conditions of Clevity, of the program of Clevity itself. So my point is, Your Lord, that if beta, that is Mr. Leith Payne's program, was wrong in concluding the trade on 10th July 2022, it would have been wrong under any circumstance, not only on during the 30 minutes period of the glitch. And if it was wrong in the first place, Clevity would have avoided the trade in the first place, and Mr. Leith Payne would have been excluded from trading beforehand itself. If Ms. Raz Rani stresses that Mr. Payne took advantage of this glitch or an error during the routine upgrade on 10th June 2022, it is essential to point out that both Mr. Payne and Ms. Razi are traders and business people on this platform. And even if Mr. Leith Payne did take advantage of this situation or this glitch, as long as he did not commit anything illegal or go against the terms and conditions of Clevity, we feel the trade was fair. Shall I move forward, Your Lord? So the disputed trade due to the routine upgrade, due to the error, which was because of a routine upgrade on 10th June 2022, was on Clevity, and Clevity is a software which is well developed, and it is prone to many such errors, and not only errors, but is also prone to hacks and other type of glitches. And when Ms. Rajdhani had been programming her algorithm, namely Alpha, if she had done her due diligence while programming Alpha and foreseen such errors or hacks on Clevity, then this disputed trade might have been avoided in the first place. Moreover, an error like this would affect a buyer like Ms. Rajdhani or her program Alpha more than it would to our client, Mr. Leith Payne, or his program Beta. It is very well established and a known fact to all developers that these algorithms develop no new changes or don't adapt to new circumstances on the platform itself. So how does Ms. Razi expect Beta or Mr. Leith Payne's program to adapt to a change that occurred on 10th June 2022, which was an error due to a routine upgrade? Both Alpha and Beta were programmed to automatically conduct such trades without having physical human interaction. And that's exactly how it worked out. So when both the programs concluded the trades, Mr. Rajdhani and Mr. Leith Payne were asleep, and they were not aware of the trade that was going on. During the 30-minute period of the disputed trade, since both the parties were asleep and both the programs concluded the trade without physical human interaction, we have to say that both the programs worked the way they were supposed to. Beta sold Apple at a certain price 250 times higher than the average price, the way it was programmed to, and so did Alpha purchase Apple at the same price, the way it was programmed to. So stating this, we have to say that if both programs have concluded the trade the way they were supposed to, then how is this not a fair trade, and how can this be considered as a mistake or a disputed trade on either end? Article 16 of International Chamber of Commerce states that the seller or a beneficiary assumes no responsibility or liability for the consequences arising due to a trade or interruption to its business. And these are the uniform rules for digital trade transactions. So pointing out Article 16A of International Chamber of Commerce, we'd like to say that Mr. Leith Payne has no legal obligation or responsibility towards Ms. Rajdhani once the disputed trade was concluded. I'm really sorry, you're not, the Wi-Fi was slow here. Yes, so as I was saying, I'd like to conclude by saying that Mr. Leith Payne has not violated any terms or conditions of Clevity platform, nor has he committed any illegal activities with this disputed trade as such. And we request the court to dismiss this claim as per our arguments. Thank you, Lord. I will now request my co-counsel Mohammed Omar to address the second issue of jurisdiction.
hold on, please. I think before we do that, I think the next speaker is going to be for the respondent. But can we just ask you? You seem to be asking us to effectively ignore the fact that there was a computer malfunction here. Can you just explain why you'd like us to do that?
Your Lord, with all due respect, we are not asking the court to ignore any computer malfunction or glitch. We do recognize that there was a glitch, and since it is a computer softwares like this are very prone to glitches and errors as such as the one on 10th July. We're just saying that this glitch has no reason for any disputed trade. The glitch did occur, but it was no reason for Ms. Razi to claim the trade back from Ms. Leithpain.
So do you think that the glitch had no effect at all on the trade, or are you just saying it didn't affect it enough for there to...
Yes, your Lord, I'm saying that it didn't affect enough. It did have a massive effect on both the traders and the platform itself. But my question over here is, if the glitch was not there, there is still a possibility of Mr. Leithpain and Mr. Razdani concluding the same trade without the glitch. So would Ms. Razdani issue the same charges against her client if the trade was concluded without the glitch? Because in that case, there would be no computer malfunction. Your Lord? Am I audible, your Lord?
We may have to stop the timer because Lee is not... Oh, he's joined back. Mohammed, could you wait for a moment until Lee is with us?
Sure.
I'm with. I was going to say I'm with you. I just I did the same as you. I put myself on took the video off to preserve the bandwidth. Hopefully that's better for everybody.
Mohammed, please continue. Mohammed Shoaib, please continue.
Your Lord, I've concluded with my arguments. Are there any questions you'd like to for me to answer?
None from my side. Lee, would you have any comments or clarification that you may wish to seek?
I don't think so at this stage. I've asked the one question that I was proposing to ask the senior appellant. Am I right in thinking that the next speaker should be the senior respondent?
Yes, you are right. Fatima, over to you.
Thank you,
Thank
Lord.
you. May it please Your Honor, I am Fatima Zahra Isaac and I appear in this matter on behalf of the respondent, Ms. Razrani, together with my learned friend Roshni Mehreen Sayed, and the appellant is represented by my learned friends from the University of Bolton. Before we begin, we find that the court must be notified that our oral submissions will contain 2 cases that have not been addressed in the submitted court bundle of the respondent. We ask that Your Honor excuses the same. The facts of a case for your convenience have already been stated by the appellant. That being said, I will move on to my submissions. The first ground to be discussed pertains to jurisdiction of the case. Most national online contracts are generally expected to have a choice of forum clause. However, the judge did not err in concluding that in the absence of such a clause, the node of clevity being in the DIFC is sufficient to qualify that DIFC has jurisdiction. Our first submission, Your Honor, is that cryptocurrency is recognized as property. This was established in AA and Persons Unknown and others reported in the 4th volume of the weekly law reports of 2020 on page 35. The core of this case pertains to whether Bitcoin or cryptocurrency is property. Mr. Justice Bryan recognized in this case that Bitcoin and cryptocurrencies, though intangible and unable to be enforced by actions, are recognized as property. Therefore, cryptocurrencies are a kind of property symbolically delivered with the help of a node's function to record transactions and keep track of distributed ledgers. With the conclusion of the first submission, we submit, Your Honor, that cryptocurrency is property, and using an analogy of law, it is our objective in the second submission to compare it with sale of goods by auction so that we may establish jurisdiction. To begin with, I submit that the grounds for the forum non-convenience test established in Spiliada Maritime Corporation and Cancelix Limited, reported in the third volume of the Weekly Law Reports of 1986 on page 460, are satisfied. In it, Lord Gough quotes Lord Keith when he stated that a natural forum is one which the action had the most real and substantial connection with. Furthermore, he mentions additional conditions such as the law governing the transaction, where the parties reside or carry on businesses. But the condition most substantial to our case is the jurisdiction being transferred to the better available forum who is more appropriate for the trial of the action. The law in Oman legally recognizes crypto trading. However, they do not have any regulatory frameworks governing the same. The Dubai Financial Service Authority, on the other hand, is one of the only locations in the world that has introduced a crypto regulatory framework. Along with the fact that Ms. Razi is the buyer in this transaction, as per the conditions established in Spiliada, the DEC court is the most appropriate and immediately available forum to adjudicate the disputed trade. It may be argued that the transaction occurred in Dubai and not the DIFC, which is an independent jurisdiction from the UAE. However, Article 5, Section A, subsection 1B of the Judicial Authority Law transfers jurisdiction to the Digital Economy Court for crypto-related disputes. Your Honor, our last submission would like to strike comparisons with auctions and crypto trading. Auctions is defined in Pitchfork Ranch Company and Bar TL Ranch, reported in volume number 615 of the West Pacific Reports on page 541, is a public sale of property to the highest bidder by one licensed and authorized to do so, and the goal is to obtain the best financial return for the seller by free and fair competition among bidders. As observed in the case facts, the disputed trade, and in fact all trades that take place in Clevity, are performed the same way. And when it comes to auctions, Your Honor, we may apply the Article 4, Section 1, subsection G of the Rome 1 regulations, which states that the contract for the sale of goods by auction shall be governed by the law of the country where the auction takes place. Therefore, I submit from the above submissions that the transaction took place in the UAE, and since Ms. Razi is the buyer in the disputed trade, and the UAE allows the DEC to govern the case as established previously. Thank you, Your Honor.
Do you have any questions, Dr. Parthasarathi?
None at the moment, but I think their video stopped. Fatima's video.
Could I just check, by the way, what is the correct pronunciation of your surname? Because I've got a different surname. I want to make sure I'm pronouncing it correctly.
I think the easier way out is to call me SP. SP would just work fine. Can we perhaps now move to the junior counsel?
Yes, I'm ready.
There's a bit of an echo, unfortunately.
Should I start?
Yes. Okay.
You're-
The echoes from my side. I'm going to mute myself. Okay. Yes, Mohammed, you can start. The echoes from my side. I'll mute myself.
All right. Your Lordship, my name is Muhammad Umar, and I'm the co-counselor on behalf of Mr. Payne on the case of Mr. Leith Payne against Ms. Razrani. Your Lordship, I will be presenting the issue of jurisdiction. May I proceed with the issue?
Yes, please.
Thank you, Your Lordship. If the court of first instance conclude that for the purpose of a claim to avoid the disputed trade was sufficient for the purpose of satisfying Article 37, Clause 1, Clause A, that shows Ms. Raz had a reasonable trader with knowledge of the circumstances of the transaction would have concluded that the dispute trade was a result of an error. Your Lordship, this is the second issue we will present. Do I have your permission to proceed with the arguments? Your Lordship, may I proceed with the arguments?
Yes, please do.
Starting with my arguments, did the first instance court determine that Ms. Raz proved that a reasonable trader with knowledge of the transaction circumstances would have concluded that the disputed trade was the result of an error sufficient to satisfy Article 37, Clause 1, Clause A of the DIFC contract law for purposes of a claim to avoid the disputed trade? Ms. Raz's claims against my client, Mr. Payne, is plainly misinterpreted in the light of Article 5, Clause A, Clause 1 of the Judicial Authority Statute of the UAE, which states that such claims may only be brought in the DIFC if the DIFC had exclusive jurisdiction over the dispute. Your Lordship, a question that comes to one's mind is that does DIFC law treat cryptocurrency as property? Answering this, there is no commercial regulatory body or specific law for crypto assets that considers cryptocurrency to be tangible property, which shows that such a claim before DIFC, Digital Economy Court, is obviously invalid. Your Lordship, crypto regulations are still a relatively new area for legislations in the UAE and under DIFC. Your Lordship, the regulatory bodies concerning cryptocurrencies in UAE are VARA, the first of its kind regulatory organization, the Virtual Assets Regulatory Authority, oversees and controls the trading of cryptocurrencies across Dubai, with the exceptions of DIFC. VARA is in charge of licensing and overseeing the virtual assets industries throughout Dubai's mainland. Since DIFC is not covered by VARA, such a claim should be retracted because DIFC has no specific regulatory authority that deals with such claims. At the moment, VARA is the only regulatory body that may oversee such crypto trading in Dubai. Another governing agency that is exclusive regulates virtual assets like cryptocurrencies and NFTs is the Dubai Financial Services Authority. The only thing that the DFSA controls are assets and cryptocurrencies, not their actual trades. Since neither organizations cover cryptocurrency trades in the DIFC court, both organizations that deal with the crypto trades and crypto assets are unable to in any way defend against this allegation. It is one such case that is seen as a landmark precedent for cryptocurrency related cases. On February 8, 2020, Dr. Wright, owner of Tulip Trading Ltd., witnessed the disappearance of Bitcoin from his digital wallet, said to be worth around $3 billion. He soon filed a lawsuit in the High Court of England and Wales against the developer of the company's core software, arguing that the developer had a duty to counter the consequences of the hack. Judge Falk was convinced that this was such an important issue that a fair trial should be held. But Judge Falk said that Tulip Trading Ltd. has the same duty, whose responsibilities are not specific to the core software developers. Another factor that persuaded Judge Falk to dismiss this argument was that software developers had responsibilities, but those responsibilities were designed to prevent hacking rather than counterattack their impact on the company. Referring to this case, Dr. Wright's costs were $3 billion, and his claim was dismissed, even though it was in the jurisdiction of the High Court of England and Wales. How can Ms. Raz expect her claims to be valid if they are due to fair trading under well-established crypto trading platforms? Your Lordships, that is the end of my arguments. May I proceed with the prayer? Your Lordship, may I proceed with the prayers, or you have any questions you would like me to answer?
None at the moment from my side. Could we now turn to the respondent?
Yes, can I just check that we're clear on your argument? Are you saying that because of the nature of the subject matter of the contract, that the court just isn't equipped to try the case? Or are you making a point about there's a different jurisdiction that ought to be the one that decides what happens here?
Your Honor, I'm only allowed to speak on behalf of my client, and the DIFC doesn't have any jurisdiction overlooking our case. And if there are any other courts, that is not with us, and it can be explored by the respondents, but I would like to stick to my case.
Okay, thank you. That was all from me, SP.
Thanks, Lee. Nothing from my side. So, the respondent, please.
Thank you, Your Lordship.
My name is Roshni Mehreen, and I appear as the junior respondent. My co-counsel Fatima Zahra has already established to the court that the presence of Clevity's note in the DIFC allows a jurisdiction to adjudicate the case, and I, if the court will allow it, now present the second ground, namely that the court of first instance did not err in concluding that it was sufficient to satisfy Article 37, Section 1, Subsection A of the DIFC contract law, that a reasonable trader with the knowledge of the circumstances surrounding the transaction would have concluded that the disputed trade was a result of an error. I now make my first submission. For a contract to be valid, parties must sufficiently be made aware of the terms of the contract. Contract law is clear that the terms that a party is assenting to must be explicitly made aware to the party and must be done with a reasonable notice. The importance of this was established by Lord Denning in the case of Thornton and Shoelace Parking in the year 1971, reported in the Queen's Bench 163. And furthermore, the matter of automations were considered and decided upon and viewed to be an extension of the human mind and is considered a true reflection of the owner or the person's intention or purpose. Thus, it could be stated that the assent to any trade by algorithms, as in this case, the trade and transaction made by alpha and beta respectively, the appellant's beta and the respondent's alpha could stand valid. However, as stated in the facts of this case, the glitch in Clevity's software during the short period of time led to a change and shift in the terms of the contract of the trading as compared to what the users had agreed to, and it had happened without reasonable notice. The case of Interphoto Picture Library Limited and Slato Visual Programs Limited in the year 1987, reported in the England and Wales Court of Appeal Civil Division 6, notes that the unusual conditions like the one at hand, in which users were excluded based on cash margin, must reasonably be brought to the party's attention. Thus, with respect to the two cases stated above, it can be reasonably established that the glitch and the subsequent changes to the terms were not made aware to the party. Therefore, the contract does not stand valid. Your Honor, I now proceed to the second submission. A unilateral mistake has occurred. Mr. Payne claims that as per Article 37, Section 1, subsection A of the DIFC contract law, he did not make a mistake and he did not and could not know about Ms. Raz Rani's mistake. A unilateral mistake occurs when only one party is mistaken as to the subject matter and the other party knew or ought to know about it. As mentioned in the case facts, both the claimant and the respondent were unaware of the transaction that took place. Therefore, as per Article 37, Mr. Payne is mistaken as to the terms of the contract. Additionally, Mr. Payne's statement that he had made no mistakes implied that Mr. Payne is confident in his programming for beta, and by declaring so, he implies that he was aware of the mistake caused by the glitch or any potential mistakes that would come his way. Thus, under the case of Hartog and Hollins against reported in the English reports, he assumed responsibility to warn Rani of the mistake and should not have taken advantage of the situation at hand, and his failure to do so makes the contract invalid. Thus, with the above submissions, I conclude that a unilateral mistake was made, and I request the Court of Appeal to dismiss this request of appeal.
Would there be rebuttals?
Yes, Your Lord.
Please, can you proceed to the rebuttals now?
Your Lord, is there a rebuttal session now? Your Lord, can we move forward with the rebuttal session now?
I'm happy as long as you can also hear SP. Can you hear us, SP? So I do apologize, everyone. I assume you can hear me. Is that right? You just can't hear SP. Is that right?
Yes.
No, there was some problem with my Bluetooth. I'm so sorry. Yes, sir, you can. I can hear you. Please.
Believe me, if anyone understands, I do. But if everyone can hear each other now, then please do proceed.
Sure, Your Lord. Thank you. Your Lord, I'd like to point out that Fatima spoke about the Rome Convention for contractual obligations. I'd like to note out that Rome Convention for contractual obligations was in a European Union convention, and hence the same does not apply to UAE because UAE is not a member of the EU and does not Rome Convention laws do not apply in UAE. I'd also like to point out that she mentioned the DFSA's regulatory body for cryptocurrency on this case. I'd like to let the court know that the Dubai Financial Services Authority does regulate cryptocurrency, but does not regulate cryptocurrency and its trading in specific. So even DFSA laws cannot be applied for this case.
Sorry, Mohammed, I'm just checking because I know it's extremely difficult here. I'm sure, like SP has very many virtual hearings, and I've never had problems like this before. And I'm sure he hasn't either. Can I just check you stopped speaking? Is that because that's the end of your rebuttal, or are you having a problem at your end?
No, Your Lord, I'm done with my rebuttal. Am I audible to you?
Yes, we can hear you absolutely fine, Mohammed. I just want to make sure that SP is also still able to hear everything. And if he is, then we can move to the respondent's rebuttal. Can you still hear everything, SP? Forgive me, everyone. I know it's so frustrating when the technology doesn't work. But I'm so sorry, Fatima. I'm going to just ask you to wait, if we could, until I get confirmation that SP can hear as well, if that's all right. I'm so sorry.
I heard you, Lee. I heard you very well. I wasn't able to find the unmute button for reasons beyond my understanding. I mean, we've been doing this for 2 years now.
I understand. I'm sure we'll all laugh about it later. All right. Well, in that case, Fatima, please do proceed. And we're so sorry. We're so sorry to have delayed you. Please proceed.
Your Honor, the rebuttal by the appellant on whether Roman regulations have any significance in our case, if the appellant would do it, the Moot Court rules state that we are allowed to use international laws and cases, especially considering the fact that crypto trading is still widely unregulated in many countries. And for the second point he made, it is to my knowledge that the DIFC has cryptocurrency regulatory framework and that the judicial authority law of the UAE allows it to govern on the same. That is the end of my submissions. I mean, rebuttal, sorry.
SP, it looks as though that's the end of the submissions. What would we like to do? I know that you and I have to do some marking, and we'll probably want to do that, preferably sort of speaking to each other a little bit. I gather that we're supposed to give a little bit of feedback. Is that something that you'd like to do now, SP, or after you and I have had a chance to talk?
I feel that it's better to give the feedback right now. The reason being, if we have had issues with this platform earlier, I anticipate that there would be issues once we join back in. So I think you and we have done quite a lot of hearings to actually give. I think we would largely be on the same plane.
Okay. Well, which of us should start with some feedback?
Would you mind if I went first?
Absolutely. Beauty before age.
Thank you very much. So if I may, firstly, I would like to apologize for the technology troubles that we have had over here. So it's but I can assure you that I heard the conversation very well. So you were well heard as a court. So that is something I want to make very clear. I believe the same with my co-judge too. I found the round to be quite exciting, primarily because of the fact that there was a lot of, I would say, there is a healthy level of competition and a healthy fight that took place online that we rarely get to see, which is something that we get to see only in physical hearings. So thank you so much for doing this online in the first place. Now, moving to the merits of the submissions that you just raised, I personally like a structure where you have a particular argument and then you rely on the rules governing that particular argument, and then you predicate that by relying on the DIFC rules. At the end of the day, we are doing a DEC moot court. So a heavy reliance on DIFC, and what is in it and what is not in it would be ideal from the perspective. And the second thing that I would like to emphasize is that it's such a novel area that even we are learning new things as we look at legal arguments that are arising in this particular area, especially in DLTs and crypto. So a reliance on a parallel reliance or a contemporary reliance could also be one more country which is perhaps relaxed its rules as far as crypto is concerned, is definitely Singapore. So Singapore courts have ruled on crypto transactions as well as contracts that are arising from crypto. So that could be a good parallel that you could use. So I'm just giving you some suggestions in terms of what you could use as a contemporary jurisprudence. That goes to all of you. If I were to give you some specific comments, the problem with online setup is we get to know if you read because your eyes move. So the good way of avoiding that is to have your camera as far as possible, and then have a sheet of paper just for the optics. It looks good, right? So perhaps that is something that you can do. Second thing is, of course, you could perhaps hand it over very gently to your junior counsel. So the reason why you're a senior counsel and then there is a junior counsel is you need to guide your junior counsel, and they need to build on the arguments that you've submitted. So they cannot be speaking the exact opposite of what you speak, unless other mode courts where you have for issues 1 and 2, and then you have issues 3 and 4, the other two counsels. Here it's a junior senior setup, and I think it's quite informative and educative in nature, because the junior has to learn from the senior and the senior has to learn from the junior. So make use of that. That is something that I like. It's more of a personal choice. I think that would be my feedback. As you move along in this particular competition, you will realize that there are many novel arguments that are to be made, because this is a novel area. So novelty is something that I, as a judge, would appreciate. I'm sure other judges would also appreciate the same level of novelty in arguments, especially your understanding of crypto and your understanding of DLTs, as to how DLT transactions typically take place, and how would you advise clients or when you are advising them on DLT disputes. That is something that I would strongly urge you. Other than that, I don't have any feedback. Over to you, Lee. Over to my co-judge, Lee.
Okay, well, I absolutely agree and would endorse and repeat what SP has said. I think the first thing we have to sort of mention is, SP and I'm sure have done many online hearings. This has been consistently the worst I've done, and that the problems have persisted. But I can even think of one where, I was in my chambers in my office, and somebody started doing the lawn mowing outside. So we had to go and get somebody to stop doing the lawn mowing so that our judge could hear. Now, the reason I'm mentioning this, and I can see SP giggling away as he's listening, is this is the reality of online advocacy. There are things that are outside your control. And so in some ways, it's actually been a very good thing that this happened here, because you can see as advocates what you need to do in that situation. And there are two things that you need to make sure of. Number one, you need to know whether the judge can hear you. And number two, you need to let the judge know whether or not you can hear them. And sometimes it will be appropriate to say, Judge, I just need to stop, or I'm going to stop, Judge, because I don't think you can hear me. It's really important. The last thing you want is to be talking away and not knowing if somebody can see or hear you. And it's particularly difficult because, of course, when you start to have problems, as you can see, people who are experienced with the technology, the first thing we'll do, SP did it and I did it, is we turn our cameras off to preserve the bandwidth. But the problem then is that you can't see if we're reacting to what you're saying. You don't know if you're being heard. And again, on that note, I'm going to just check, can you all still hear me? Just give me a smile if you can. Yeah. The second thing I would say is you've got junior and senior counsel for each side. Now, everything SP has said is absolutely correct in the real world. In the real world, the leader will be the more experience of the two of you. Obviously, the format of the competition is designed to simulate that. But even if one of you is junior and senior, I think my tip would be divide the issues and trust your teammate. So what I was hoping to see was that you would come in and say, right, there are 2 points for appeal here. I'm going to deal with one, and I'm going to be the only person dealing with that for our side. And my partner, my co-counsel, is going to deal with the other one. So that's a structural point. And then I think the third bit of feedback I'd give you is, in terms of the types of arguments that you're making, when you're making a jurisdiction argument and you're the one that's saying to the court, you don't have jurisdiction, you shouldn't have jurisdiction, you need to be a little bit careful about it. And this is where the kind of the dark arts of the advocate come in. What you don't want to be doing, and it's very hard to, you have to try to avoid it, is to sort of insult the court and suggest that they're not equipped to do it. Because again, the context of this moot is that this is the digital economy court. So you need to be very careful if you're saying to them, look, we don't think you've got the expertise, because the judge is going to say, well, I'm perfectly able to do it. And that's true with any court. I had a situation a couple of weeks ago where there was a jurisdiction debate, not between different countries, but between an insolvency court and the King's Bench Division of the High Court. And it's very difficult. You want to try and persuade the court that they shouldn't do it, but you don't want them to think you're saying, well, you're not capable of it, because that's like an insult. So just sort of bear that in mind, that you're asking judges who are human beings to make decisions, and they can have feelings that can be hurt, etc. And I guess the final thing I would say is, whatever argument you're making, always take a step back and say, well, what happens if we apply this universally? So, for example, if we're saying here, well, we can accept jurisdiction because one node is located in the DIFC, does that mean that any other country in which there is also a node would also have the same jurisdiction? Or is there something more that needs to be required here? And then similarly, if you're making an argument on the mistake point and you're saying, well, the parties weren't aware of the transaction, again, you have to take a step back and say, well, hold on a moment, aren't these two people trading algorithmically? Isn't the whole point of this that the computers are doing it on their behalf? So it's not just this trade it would apply to, it would have tried to every single one of their trades and every trade on the platform that's been done with an algorithm. So as I say, always take a step back and think, well, what's really going on here? And if I apply my argument to other situations, how would that look? I think those are the only three things I would mention at this stage. Thank you. SP, what do we do? It's 11:30. We're obviously running, entirely my fault, a little bit late. Do you and I go to some sort of breakout room to quickly discuss marks, or if we're running late, do you and I want to catch that up later in the day?
If you have a minute or so, we could quickly catch up. Would that be appropriate? Very well. I'll see you in the judges' room.
Okay. I'm going to hope that I know how to get to that, but okay.
Thank you very much, teams. It was a thank you very much for putting up with the technology glitch that we have had. So I think now you're better prepared to perhaps appear in international tribunals with a bit of a glitch. Here, as Lee very well pointed out, now you have been acquainted to the worst, so you can expect what average would look like.
And can I just say one last thing on feedback? When something goes wrong, try and use it to your client's advantage. So, for example, if you were acting here for the claimant, you could say, well, look, judge, we can see technology breaks down all the time and it's very frustrating. Look, maybe you now have some sympathy for my client. And equally, if you're for Mr. Payne, you have to use it to your advantage, because you can see, look at SP, he's giggling away now that I've said it, and he's going to remember that now. And so that's what you want to do, always to try and make an impression on your judge, on your tribunal. All right, thanks, guys. We'll let you go and grab some a break or some food or drink or whatever you need to do. And SP, I'm going to try and find the judges' room. And obviously, if you're in it, I'll see you there.
Thank you so much.
Thank you so much, sir.
Thank you.